Good morning, Wakili.
Good morning, Commissioner Judge.
Fatuma Sichale, karibu sana.
Asante sana.
Good morning.
Good morning, Commissioner.
Uluande Evelyn, Commissioner. You are welcome.
Asante sana.
Yes, thank you, Honorable Commissioners, for that introduction. Mr. Gichuru, you can start by telling us your county and your ethnicity.
Thank you, Madam CJ. My county is Uasin Gishu and my ethnicity is Kikuyu.
Very well. If you could briefly, in 5 minutes, we have read your CV and the sample writings you provided us. We want to hear from you your vision for the High Court and how your qualifications, your experience, your knowledge fit for you to be recommended for the position of a judge of the High Court, and what values you'll be bringing to that position.
Thank you. Thank you, Madam CJ. I'm Edmond Kiplagat Gichuru, an advocate of 20 years standing post-admission. I am a graduate of Moi University, Nairobi University and Syracuse University, in that order. I'm currently the head of Historical Land Injustice at the National Land Commission. I've also been privileged to be appointed by this commission to be a member, a part-time member of the Sports Disputes Tribunal. And my term ended in the month of May last year. I bring with me judgment writing skills, research skills which are essential to this position. The values that I hold dear: number one, integrity. My character has never been impeached or impugned in any way or form. The second value I bring is that of benevolence. Parties who come before us come at the mercy of the High Court, really, and that was the experience with us at the Commission. And as the Commission exercised its power under the Constitution to determine cases that touched on historical land injustice, this was a quasi-judicial function, and so parties would come before us in that sense and at the benevolence of the Commission, and this also occurred with respect to the tribunal. The last thing that I bring as a value is the issue of self-control. Land matters in the Commission are high voltage and very emotive, and you need to have control, and that is what really helps to be objective and to pursue the end of justice at the end of the day. And the same applies also with the Sports Dispute Tribunal. My vision really is to see a judiciary that will be the last resort. Kenyans will say, if everything else fails, the judiciary is there for me. For me, Madam Chief Justice, Honorable Commissioners, that is what I count as the most cardinal and my true north. Thank you.
Thank you. Did you tell us the vision of the High Court? What vision you have?
Thank you, Madam CJ. So the vision I have is to really help the judiciary deal with the backlog of cases based on the experience that we've had at the Commission and also the Sports Dispute Tribunal. We've been ranked twice in a row, really, as the best tribunal with 500 cases and below. One of the things that really helped us was to cut down on the backlog, and this speaks to the call of the Constitution to ensure justice is not delayed, but also speak to access to justice so that the efficiency with which we clear the cases coming before us also speaks to access to justice. So these are really subsets of the vision that I have, should I be granted the opportunity. Thank you.
Thank you. Commissioner Mwansa. who will take us to the next level of questions.
Thank you, CJ. Council, I've heard about your vision.
Yes.
Perhaps I just want to ask you one or two questions about that.
Okay.
Now, if you read Article 259 of the Constitution, 259(1),
Okay, yes.
it states that the Constitution shall be interpreted in a manner that C, permits the development of the law.
Yes.
Permits the development of the law. And D, contributes to good governance. And then when you read Article 21, it provides that the Bill of Rights, in applying the Bill of Rights, a court shall A, develop the law to the extent that it does give effect to a right or a fundamental freedom. So my question is, how does the High Court exercise its constitutional power to develop the law? And if you can give us one or two instances when that has happened.
Sorry, thank you, Commissioner.
That's all right, you can have your water.
I think, Commissioner, the development of the law in that sense means that the High Court, with its unlimited jurisdiction on matters civil and criminal and other jurisdictions, judges are supposed to give effect to the law to circumstances that arise in every sense, or novel situations, or disputes that are new in a sense. One case I can give is that of Eric Gitari. In a sense, that was a new frontier, because looking at the right to marriage and the right to association, this is a situation where it was bound to have the effect of a debate across the country, yet the right to association is what the Supreme Court was able to expand on.
Okay, no, I'm not talking about the yes. Supreme Court. Because you seek to
yes.
join the High Court.
Yes.
An instance whereby
yes.
the High Court has developed the law
yes.
using this this constitutional instruction
yes.
that developed the law.
Yes.
And as you answer that,
yes.
What is the extent that the High Court can go in developing the law, so that it does also not legislate or create a situation whereby it is infringing on the legislative power of Parliament?
Well, thank you, Commissioner. So I think there are principles or doctrines that guide the interpretation of the law, so that you exercise this power within those limits. For example, there is the doctrine of judicial restraint, so that you don't infringe on the mandates of other government agencies, like Parliament.
But judicial restraint is not developed in the law.
So you are developing the law,
yes,
but within particular limits that help you not to infringe on the basis of separation of powers, but still speak to a subject that develops the law in a sense.
Okay. And lastly,
yes,
there is the constitutional doctrine
yes.
of severance.
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 Sorry, Commissioner, I've heard about many of these doctrines. Severance, perhaps you could clarify. Yes.
So as you are interpreting a statute,
yes,
as a High Court,
yes,
and there is a challenge on the statute,
yes,
about its unconstitutionality,
yes,
so there is the doctrine of severance.
Okay.
That I wanted to hear, because I will tell you up to there.
Okay.
Then I just want to know whether you are aware about that doctrine.
So that's a statute vis-a-vis the Constitution.
Yes.
Okay.
Yes.
So in terms of Maybe I wasn't clear on that, Commissioner.
So the doctrine of severance, it's an
Yes.
interpretive tool
Okay.
that is used by the High Court
Yes.
when a statute has been challenged
Okay.
or attacked,
Yes.
that it is contra the Constitution.
Okay.
Yes.
So
I-
that, okay.
Yeah.
Okay.
Are you aware about that doctrine?
I've not heard about that, but I know,
Okay,
of
okay.
course,
All right. What about reading in?
reading in.
Yes.
No, I've not heard of that as well.
Okay.
Yes.
All right. Thank you.
Thank you.
All right. Thank you, CJ.
Commissioner.
Thank you, Justice Ishara.
Thank you, Honorable Chief Justice. Wakili,
Yes, Commissioner Judge.
the retired Constitution,
Yes.
and in particular the Criminal Procedure Code,
Yes.
Section 87A, provided that the DPP could terminate a case at any stage.
Yes.
Has that position changed in the 2010 Constitution?
Yes, Commissioner Judge.
Yes.
In a sense, the only thing that I think the only addition is that he can only do that with the consent or the authority of the court.
All right.
Yes.
He can do so with the blessings of the court.
Yes.
So fast forward,
Yes.
imagine that you are now a High Court judge.
Yes.
There is an appeal that is pending before you.
Yes.
The office of the DPP has filed an appeal,
Yes.
and their complaint
Yes.
is that the court has they made an application to the
Yes.
court to withdraw the charge against an accused person,
Yes.
and the court refused to have the charge withdrawn.
Yes.
What are the considerations that you will put in place in making a determination one way or the other?
Thank you, Judge, Commissioner. So one of the things I look at is the nature of the charge. Secondly, I will look at whether I think for me, maybe you can assist, break it down.
Right. I mean, it's an appeal that is now before you,
Yes.
and the DPP's office is saying we made an application before the court wanting to withdraw the charge, but the court refused. So that is their complaint that you're handling.
Okay, it's not an absolute yes.
Does it matter what stage the matter had reached at the lower court?
Sorry. Yeah, so it should only happen before the proceedings are over.
What
So-
do you mean by proceedings?
So,
you know proceedings, yes.
Okay, if it's in a criminal case.
Yes, it's a criminal case,
Oh, it's
the
a criminal
DPP,
case.
yes.
Yes, sorry, Judge, Commissioner. So if it's a criminal case, then that is before sentencing, but after taking of the plea. Okay, maybe just to explain it further, it can only be done if it's after the taking of plea. Number two, if it's done after the taking of, before sentencing, the accused will be set free. So I hope I'm just trying to tie that with what I see in the Criminal Procedure Code in terms of.
You say before sentencing.
Before I know conviction comes, then sentencing, but before conviction, but after plea. It has to come after the plea has been taken.
What happens after somebody pleads not guilty?
Okay, the Constitution provides that he can do it at any stage, but when you look at the Criminal Procedure Code, it now goes down to break it down at what stage, so long as it's with the consent of the court.
I'm not so sure that the Constitution says that you can Okay, you can do it at any stage, but what are the consequences?
Oh, so one of the things is that it doesn't serve as a bar for future prosecution.
So are you saying that when the DPP applies to withdraw the case, you don't get a complete acquittal?
You don't get a complete acquittal.
You
Yes.
just have a discharge.
You just have a discharge.
That may not entirely be correct, and you would
Okay.
need to check the constitutional provisions,
Okay.
Article 157. And then finally from me, because the DPP is in charge of prosecutions,
Yes.
can he take over a matter that is in a court martial?
No, he can't.
Why?
The Constitution provides that that is outside his remit.
All right, thank
Yes.
you. Thank you.
Thank you.
Honorable CJ and Wakili, once again, welcome.
Thank you, Judge Commissioner.
First, let me congratulate you
Thank
on
you.
behalf of the Sports Tribunal for the good work you've been doing.
Thank you,
The
Judge.
tribunal has been one of the extremely good working tribunals in the country.
Thank you, Judge.
And two, I heard you in your introductory remarks that you work at the National Land Commission.
That's true, Commissioner Judge.
Okay, thank you. Now, what's the mandate of the commission, that is the NLC, on historical injustices?
Oh, thank you, Commissioner Judge. So this function is actually provided under Article 67(2)(e) of the Constitution, and then that provision is further effected by Section 15 of the National Land Commission. So what it provides is that the Commission will investigate either on its own motion or upon a complaint made to the Commission over a matter that is of a historical land injustice nature, and that is either historical or present. Then the Commission will make appropriate recommendations.
Does the commission have powers to make a definite finding or just to recommend?
To recommend. To recommend, because when you go to Section 15, it gives effect to Article 67(2)(e), and what it provides actually under Section 15 is that the institution or the authority mandated to implement recommendations emanating out of those proceedings have a period of 3 years to effect that.
So in these cases of historical injustices relating to land,
Yes.
to which institution do you make recommendations to?
So it depends really with the nature of the proceedings and the claim. So sometimes if it's an issue to do with a settlement that was irregularly done, that will be the Ministry of Lands. If it's an issue to do with colonial displacement, again, that will be the Ministry of Lands. If it's an issue to do with IDPs or persons who've been displaced because of political motivated violence, that will be the Ministry of Interior.
Okay. Now, as you may be aware,
Yes.
there has been this never-ending land problem within the coastal region.
Yes.
Many names given to it. Sometimes it's referred to as a squatter problem. Sometimes it's absentee landlords.
Yes.
And all this. And the situation is very pathetic.
Yeah.
We have seen instances where families are evicted, whose great-great-great-grandparents lived on the land over hundreds of years because of the adversarial nature of our court system.
Yes.
Then comes NLC.
Yes.
But for the period NLC has been there, I do not think whether it has had any positive impact on this historical issue of land within that region. Because even as at now, people are being evicted. Has this a problem reached your desk or someone is yet to complain?
Thank you, Judge Commissioner. The problem of land at the coastal province formally really has reached the Commission, and yes, my desk. And as the head of the Secretariat supporting the Commission, actually, I have to process these claims to determine their admissibility. So the law has also set out an admissibility test to determine which cases fall into this category and those that fall by the wayside. So we have been to Kilifi County, Kwale County, Mombasa County, largely. And recently we, as a commission, addressed the issue of absentee landlords. And this was done by the second commission. We are now in our third cycle. We are waiting for commissioners to, as a matter of fact, the process of recruitment was ongoing, but it was suspended and finally quashed by the courts. But to address the issue of squatters, largely who fall under the category of absentee landlords, we recommended policy directions, because one of the challenges we also had was they have this arrangement they call it's a tenancy at will, where courts have also called it houses without land. So they come and build houses on land that is owned by the absentee landlords. Most of them are Omani citizens, but they pay nominal rent. So we made policy recommendations because the commission felt that the arrangement falls outside the historical land injustice test under the law, to the extent that these houses are not livable, the conditions are not good, the planning situation is not good. But yes.
Maybe you hold it there. I'm actually at a loss as to how policy recommendations will be able to annul title documents, because we are talking about cases where people have come up with title documents.
Yes.
The commission, the much it can do is to make policy directions on this, because on one hand you have the complaint about historical injustices, on the other hand you have people with documents. When you go to court, it's an adversarial system. These people are not able to move anywhere. Many of their suits have been thrown out.
Yes.
Do you think this commission is serving any purpose to the common man?
Thank you, Judge Commissioner. Yes, I think it is. I know for a fact some of these...
Can it make recommendations to annul a title deed?
It can, under the law. It can, under Section 15, if it has been acquired illegally. But one of the challenges, of course, we are having is documentation. And I agree. If the squatters come without documents, it's a challenge. I know where we've made progress is in matters, settlement scheme and adjudication sections. Those are easy because they're able to provide evidence. But for land that is held by absentee landlords, I think the bigger picture is they have no documents. I agree. The policy recommendations were made because what the commission felt is it may not have a remedy at the time, but it will not leave the claimants without any form of remedy. It's policy, yes, but it's something that the commissioner felt, despite the fact that admissibility was an issue, they made recommendations that the county government and the national government should be able to implement.
To me, yes. Just as I come to an end of this discussion, to me, the role which ought to be played by that commission is inquisitorial, so to say.
Yes.
But you see now, when you go back to say admissibility of documents and presence of documents, you are going back to the normal adversarial system. And that is why I'm having a problem, with that commission. Now, in that state, we have you now in the High Court.
Yes.
To me, it would be like transferring that issue of inability to be productive, so to say, to the High Court. Because to me, the Commission is not making any headway.
Thank you, Commissioner Judge. The issue of admissibility really is not on the basis of evidence. What the law has said, actually, and this is what Parliament promulgated as the law, is that when claimants or Kenyans file these cases of historical land injustice, you subject them to requirements under the law. For example, if there is a court case, and there are situations where there are court case, or if it's been decided before, that falls by the wayside. Yet again, Commissioner, I serve in the Secretariat, and the final call is actually with the commissioners. They make the final decision. The Secretariat gives its technical input, does the investigation, but the commissioners make the final call.
Okay, thank you very much. I wish you well. That's all.
Thank you, Commissioner.
Thank you, Chair. Good morning once again, Council.
Good morning, Commissioner.
Do you want to take a water break?
Oh, thank you.
Thank
Yes.
you.
Thank you.
Okay. I've gone through your sample writings. You shared with us submissions, journal articles, and judgment in the sport tribunal, in a sport tribunal matter. They do portray your strengths in adjudicative, advocacy, and scholarly work. They demonstrate strong command of legal doctrine, excellent issue identification, and rigorous analytical reasoning. I noted that in the anti-doping matter, you applied strict adherence to regulatory regime. You were like, this is what the regulations speak to. And in the other matter of, there's an article you did on right of persons with mental illness. You did make very novel arguments. You were able to draw from regional and international best practice and made recommendation on why we need to have our Mental Health Act changed. Your tone is professional and well balanced, so I must commend you for that.
Thank you, Commissioner.
My question,
Yes, Commissioner.
is in the last census, we had 1,552 intersex persons. That is the number that Kenya Bureau of Standard were able to come up with. What is your understanding of who an intersex person is? And does an intersex person have rights under Article 55(2)?
Thank you, Commissioner. An intersex person, I'm trying to get the most just a way to describe appropriate yes word. So that would be a person who is both male and female. And your question on Article 55(2).
Sub-Article 2.
Sub-Article
45.
45.
Can make the issue of right to marry. Maybe you can make reference to it.
Oh,
and,
okay.
Based on your
So
definition, which you must, I request that you look that up. But
so
yes.
The remit of that article is to the effect that only two persons of the opposite sex can marry. So in this situation, the interpretation is that such a person would not meet the dictates of section Article 45(2), but it doesn't mean they can't associate.
I'm just I'm more focused on the issue of the right to marry.
On the right to marry, yeah. So that is the ingredients really in terms of what defines marriage is what gives that limitation to that situation.
So then intersex persons have no remedy from the Constitution if
No,
they
in terms
would
of
want to marry.
so once the Constitution pronounces itself to that effect, so that's the situation really, unless the law changes. But it doesn't mean you can't fashion a remedy for them, not necessarily for marriage, but for any other controversy or issue that is placed before you.
Okay, thank
Yes.
you. All the best. Thank you.
Thank you.
You have a matter, you are a High Court judge now,
Yes.
hypothetically, you have a matter that comes before you. The petitioner
Yes.
says that he was part of a demonstration
Yes.
in the precincts of Nairobi.
Yes.
During the demonstration, there was a lot of activity, tear gassing. Some of the shops in the streets of Nairobi had their windows broken. There was some looting. And he finds himself, having left the demonstration, he finds himself at home, where he is then arrested by plainclothes officers before he is taken to the DCI and then brought to court. His lawyer
Yes.
is claiming that many of his rights were violated, including his right to privacy, because he says that he was found at home through the tracing of his phone activity by intelligence officers. So he is claiming, among others, a violation to his privacy. The Attorney General, on the other hand, comes and says that there is criminal activity that took place, and therefore the state may use means, including the invasion of the right to privacy, in order to make such an arrest. What would your finding be, looking at the Bill of Rights, looking at the different the rights to violation that are being claimed, and the defense, therefore, of the state?
Thank you, Judge. First, in the Bill of Rights, the right to assemble is cardinal. And in such a case, one of the findings I'll make is that so long as it's peaceful, the right to assemble is guaranteed. In terms of privacy, that's also protected under the Constitution. But I think I'll have a problem, let me not say I think I'll have a problem with the manner in which the police extracted the evidence without the superintendence of the court, because for issues to do with such, and even seizure, that has to be subjected to a court process. But the right to privacy is cardinal. I'll protect. For me, I'll uphold that right in the circumstances.
Let me follow that up. The National Intelligence Service has a statute
Yes.
that allows them to gather intelligence
Yes.
and to identify internal and external threats.
Yes.
And this is the argument that the Attorney General is bringing to you, stating it is allowed under the Constitution when you look at Article 24.
That's true. Article 24 limits the rights, the fundamental rights and freedoms.
So now apply it, because your answer
Yes.
has not taken that into consideration.
Thank you, Judge, Commissioner. Yeah, so you can only limit that if the law provides, and depending on the nature of the fundamental right and freedom. And these are tests that have to be established if that limitation is to take place. But the fact that the National Intelligence Act provides for surveillance and intelligence that alone is not sufficient to use as evidence to limit that right, or used as a ground to limit that right. The proper framework is really, in fact, the Constitution is supreme. So in terms of putting them in the weighing scale, the Constitution runs supreme, and the police or the DPP or the investigator has to show that he has done this within the limits of Article 24.
Thank you. Thank you.
Thank you, Judge.
No, it's me. Thank you, Chair. Good morning once again.
Good morning, Commissioner.
Yes. On what considerations would you allow an application for review under Order 45?
So 3 grounds. Mm-hmm. Number 1, if there's a mistake apparent on the record. Mm-hmm. Number 2, if there's new evidence. And number 3, any other sufficient ground.
Okay. Now, suppose parties appear before you.
Yes.
On a matter that you handled previously.
Yes.
And one of the parties who's aggrieved.
Yes.
Has appealed to the Court of Appeal.
Yes.
Then the other party, who is essentially now a respondent in the Court of Appeal,
yes,
has applied for review before you.
Yes.
Would that wash, in your view? The application before you, can it stand?
I don't think it can stand unless they stay that I have issued, because the fact that you have filed an appeal and there is a review, the appeal does not, the court is functus officio, yes, but my jurisdiction for review has been invoked. So unless I order stay, I think I'll be able to proceed with the review. Stay of execution, sorry. So because if it's a judgment, definitely there'll be a decree that will be issued, mm-hmm, and a party who feels.
Okay, I have not gone to the realm of execution yet.
Oh, okay.
Yes. So one party, aggrieved by your decision, has filed an appeal in the Court of Appeal. Sorry.
Yes.
And the other party, who is essentially the respondent now in the Court of Appeal,
yes,
has applied for review before you. Can his application stand?
Okay, just to get your clarity, sorry, Commissioner.
It's okay.
Maybe you can break it further, because you are saying judgment has not been entered. We've not reached the point of execution.
You see, there's judgment,
yes,
and there's execution.
Yes.
I'm not talking about execution.
Okay.
Of course, we can't be appealing if there's no judgment or a decision,
yes,
at least.
Yes.
Yes. So now, maybe let me make it simpler. Yes, you've rendered judgment in a matter.
Yes.
So one party is aggrieved.
Yes.
That party has filed an appeal in the Court of Appeal.
Yes.
The other party, who is now a respondent in the Court of Appeal.
Yes.
So of course that is a successful party before you.
Yes.
Is seeking review.
Yes.
Can his application stand?
I think I'll allow his application can stand.
His application can
yes.
stand. Yes. Are there exceptions? Are there instances where that application cannot be sustained before you?
Maybe if there's an order from the Court of Appeal staying the proceedings.
Okay.
In the High
yes.
Court.
But are there other instances other than where there is a stay?
I think that's what I can think of.
Okay. Maybe you'll appraise yourself of Order 45,
okay.
Rule 1, Sub Rule 2.
Thank you.
It will give you the answer there.
Okay, thank you.
Okay, you told us you work at the National Lands Commission.
Yes, Commissioner.
You are the head of...
Historical Land Injustice Secretariat.
Okay.
Yes.
So I was reading your CV,
Yes.
and you say you set up a case management system there successfully.
Yes.
Can you just briefly tell us how it works?
Okay. Thank you, Commissioner. So the way the quasi-judicial function of the Commission with respect to historical land injustice is structured is that we have the commissioners at the top who make the decision. They sit as a panel, and then the Secretariat, for which I'm privileged to head, supports them functionally on a day-to-day basis. So the registry is important because these are quasi-judicial function. So parties file their documents, claimants will come with their claims, file their documents, and respondents will respond. Interested parties will file, or anybody who has an interest in the matter. We have a registry, a physical registry, but we also have a virtual registry. So this function of the Commission, or mandate really, because it's a constitutional mandate, began in 2017. The legal framework was promulgated by Parliament in 2016.
Allow me to interrupt you. My colleagues are waiting to also engage you.
Okay.
I'm just asking how that case management system works. I'm not asking about your function or your structure, just how the system works.
So
the one you set up.
Or the one we set up.
Mm-hmm.
So of course we have all the files for the claimants. We are able to track the cases from the time the cases are filed to the conclusion when determinations are issued. That's the final outcome, and parties can access information from the registry. We've linked it up also with our portal, public portal, and we are not yet there, but we are integrating. We are interfacing with our public portal, even though what we have also done is digitize the processes, and then we will link it up to the public portal so that parties really don't have to come and ask from the headquarters or our branches across the country. They can interact with the system online.
Okay.
Yeah.
Okay, thank you. I wish you well.
Thank you.
Thank you.
Thank you, Honorable Chair, and welcome again, Wakili. Now,
Thank you.
What does Chapter 6 demand of a judge? And please tell us how you will apply the principles in Chapter 6 as a High Court judge.
Thank you so much, Commissioner. So Chapter 6 is on principles and values of public service. So
Chapter 6.
Oh, leadership and integrity, sorry. Leadership and integrity. And there are principles that a public or a state officer ought to display. One of them is being a servant and not a leader. In this sense, all authority emanates from the people. And when they come to us for service, even as a judge, I sit at the behest of the people of Kenya, and I'm supposed to treat them with respect and serve them. Number two, accountability. I have to account for my time and the resources that have been really provided for me to be able to carry out the work. And this accountability, apart from the people, there are other state agencies that I have to account to through the judiciary, which I'm accountable to. And lastly, I have to ensure that in a recruitment process, there's fairness and merit. Anytime I have a chance to be nominated to sit in a recruitment exercise or a panel of recruitment exercise among many.
Okay.
Thank you.
Thank you. I wish you all the best.
Thank you, Commissioner.
Thank you, Honorable CJ. Wakili, a few questions for me.
Yes, Commissioner.
What is your understanding of mentorship?
Yes.
And maybe you could give us the benefits of mentorship to mentees.
Yes.
Any two benefits to mentors, and maybe any two to the organization.
Okay. Thank you, Commissioner. So to mentees, number one, transfer of knowledge.
First, you tell us what is your understanding of.
Sorry.
Yeah.
So my understanding of a mentorship, Commissioner, is mentorship is a situation where you help those who are under you grow, and you lead them on paths that help them really develop their experience in terms of work, academics. So you lead the way, sort of, to say. Yeah.
Okay.
In terms of benefits, number one, to the mentee, of course, you're able to shape them and help them take steps that will really help them grow. Secondly, you also are able to show them the pitfalls to avoid out of experience, so that they don't get entangled in that. To the organization, it's a good thing, because one of the things that I know we struggle with is succession planning. So if you don't mentor the people who work under you, once you exit the organization, they'll not be able to take over from you. Secondly, I think it's also a no-cost training in a way, because this is something you are doing, and you don't need training for that, for the organization in that sense. Then so it was the mentor also?
Yes.
I think for the mentor, fulfillment, because when you see people grow, you are able to get the fulfillment and know that you have made the organization better than you found it. And secondly, I think for you also grow, because you learn every time you pass on knowledge to the next generation.
Okay. Finally, for me, what do you do when you're faced with multiple tasks with conflicting deadlines?
Thank you, Commissioner. The first thing I do is I prioritize what is urgent, what's not urgent, in that formula or format. But secondly, delegate what I think I need to do, and what I can delegate, I'll delegate.
Are there roles you feel you will not be able to delegate as a judge?
Yes.
Which ones?
Taking charge of my proceedings in court, writing judgments or rulings. Those ones I can delegate, and roles that really I need to undertake as per the law.
Okay.
Yes.
Thank you, and I wish you well.
Thank you, Commissioner.
Good morning again.
Good morning, Commissioner.
I hope you are relaxed.
Oh, yes.
Okay, fine. Now, what role should developing countries play in shaping global governance norms rather than merely adopting them?
Okay. Or maybe a request for, if you could kindly repeat, Commissioner.
Okay, let me ask you another one. How familiar are you with international and regional legal instruments relevant to your field?
At least I have some knowledge to the extent that I have related with in the course of my work. I have a Commissioner, I understand how they operate in terms of the entry point in the Constitution, Article 2, 5, and 6, and how to apply them locally. And I know as a judiciary we have done that in a number of cases, including the Me Too Bell case. where we applied conventions on evictions, and I know we've also applied it in the Rono and Rono case, where the judges of the Court of Appeal applied the CEDA, what we call the Convention Against All Forms of Discrimination Against Women. So you can apply them locally, especially when you want to develop the law, or where there are gaps in the law, or where there is no law.
How should courts or institutions approach conflicts between domestic law and international law?
Thank you, Commissioner. So there's a test to apply under Article 2.5 and 2.6. Of course, all rules are part of Kenyan law, all international rules, sorry. Under 2.6, any treaty ratified by Kenya is part of Kenyan law. But if a treaty has not been ratified, then it's an international instrument, but it will not apply. Or where there is a conflict, domestic law prevails.
Okay, thank you.
Thank you very much. I think we are nearing to the end of this interview, but I just want to hear from you.
Yes.
What are the benefits have we derived as a country from devolved government?
Thank you, Madam CJ. Number one, we've taken services closer to the people. That was not the case before.
Which services are these?
Oh, thank you. So, govern in terms of the political structure of the country. So, we have leadership or governance at two levels, at the national and county, and residents of each county are able to determine their political direction insofar as that county is concerned, and determine during elections who will take over office and who most fits who most fits the job for purposes of advancing the county. But number two, resources. The Constitution has also introduced the issue of devolving resources down to the people through the division of revenue bill and the sharing of the national cake once every 4 years. But every year during the financial bill, a certain percentage of resources go down to the people. Then number three, I think my assessment is that it has to some extent also reduced the competition for national politics, so that you don't have to all fight because we all want our candidates to win. We can benefit also at that local level in terms of the political rights as provided under the Constitution.
Yes, so in your view, do you think the objects of devolution have been met?
Thank you, Madam CJ. They have to some extent. We still have to, we can do better. I know we've had cases of accountability where resources have not benefit the people 100%. The other thing that we are still dealing with is the issue of, apart from that, the issue of cohesion, because I know as a country sometimes we are not able to accommodate everyone who is from a different community. We have instances where data has been provided that The county governments have hired certain persons to the exclusion of others, maybe on the basis of ethnicity.
So we have not done well as far as the principle of inclusivity is concerned in the
Madam
counties.
CJ, yes.
Okay, I don't want to ask you what can be done
Yes.
to remedy that. I will spare you from that.
Thank you.
Justice Ishale, yes.
Thank you, Honorable Chief Justice. I have a question that is outside the interview.
Yes, Commissioner.
I'm just looking for information, as it were. Article 168 of the Constitution makes provision that there'll be legislation that will be enacted to take care of maximum and minimum acreages in respect of private land.
Yes.
Has that happened?
So there was, thank you, Judge. So there's a provision that has been provided under the Land Act, but it's not been implemented. So I think the debate around it is that it's not settling well with everybody, and implementing it is a challenge, because I think there are people who feel these may not augur well for them, especially the large land holders. But there's a provision in law, but it remains unimplemented.
All right, thank you. Thank you for that.
Thank you, Judge.
Thank you. I think this now brings us to the end of this interview.
Thank you, Judge.
But before we release a candidate, we always give them an opportunity to also engage us. The floor is yours.
Thank you, Madam CJ. I don't have any question, but to just extend my utmost gratitude to the panel led by Madam CJ and the eminent judges and commissioners for the opportunity to appear before you. It's not something I take it for granted. I have applied before for this position, but this is the first time that I've reached this level, so I don't take it for granted. And I wish you the very best. It's not an easy exercise, but may God guide you as you move the process forward. Thank you.
Thank you on behalf of the commissioners. We also wish you success. We will get in touch with you when we complete the exercise. As you know, it's a very competitive exercise, so we always wish the candidate well and encourage them to continue working hard and getting focused to serve in whichever way you're serving the people of Kenya, to continue doing the right thing and working hard. So, all the best.
Thank you, Madam CJ.
Yes, you are released.
Thank you so much.
Carry your writing pad.
Thank you so much.
And your water.
Oh, thank you.